Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, we talk about civilian disarmament a lot on this channel, and we talk about different segments of the population who could be subject to civilian disarmament legislation. The one group, whenever they are mentioned, that perhaps gets us most riled up here, most furious at Washington Gun Law, is when anyone ever proposes a plan to disarm our veterans. Now, as you know, I've been very clear, I did not serve in the United States military, but I have a deep level of gratitude and admiration for everyone who did, and I think it is one of our communities that we need to protect the most. Along comes a piece of federal legislation that essentially is going to subject everybody in the military, and when I mean everybody in the military, I mean everybody, to be involved in state red flag hearings. It is yet another way that they're going to try to disarm you, the lawful and responsible gun-owning American. So today, let's geek out on the legislation for a bit, and let's talk about how they'll disarm our veterans. What do you got there, man?
TacPack.
Oh, sweet. A TacPack? Nice.
Oh, what's a TacPack?
That's the new sponsor of the channel.
So what's in a TacPack?
Oh, what's in a TacPack? Well, here's the best thing. It is a monthly subscription of all sorts of tactical gear. And I mean, they got a lot of really cool stuff. The best part about it is that they actually have two separate subscription models. So they got their TacPack Standard, which ships at $59.95 a month. Best thing about that is it really has a value of about somewhere between $90 and $120. And then they got the TacPack Plus. Now that ships at $139.95 a month, but, oh, check this out. They actually have a value of somewhere between $240 and $300.
Wow, that's pretty cool.
Yeah, it's super cool, and here's the coolest part yet, because if you sign up right now for the TacPack Plus and you use the promo code GunLawYT, you're going to get an extra $60 everyday carry kit, which means that your initial investment for less than $140, you're going to be ended up getting over $300 worth of tactical gear. Listen, look at some of the cool things you're going to get if you subscribe to TacPack today. So get down there, check out the link below, make sure you use the promo code GunLawYT. Check out TacPack. Okay, America, here's what we're talking about. We're talking about a new Senate bill in the United States Senate. It has now been assigned the number of 5055. The piece of legislation is entitled the Armed Forces Crisis Intervention Notification Act. And it is being introduced by Republican Senator Susan Collins and Maine Independent Senator Angus King. That's right, a piece of civilian disarmament legislation being proposed by a Republican senator, a piece of civilian disarmament legislation targeting our veterans. Now, here's what the legislation doesn't do. What it doesn't do is it does not create a federal red flag law. It does not create red flag laws that operate only within the military structure, okay? It does not do any of that. No, it actually does something far more nefarious than that. Because what this piece of legislation would do, if enacted into law, is it would mandate that all military installations comply to the fullest extent with whatever applicable red flag state law is in place. So, for example, I live here in Washington State, JBLM, Joint Base Lewis McChord, right down the freeway from here. Huge military installation, okay? Both Air Force and Army. If an incident were to occur with a soldier serving at that installation, the commanding officers by this legislation would be mandated by law to immediately report to the local authorities. That would be the Pierce County Sheriff's Department down there where JBLM is located. And then after making the report, they would also be required to cooperate completely in the actual red flag hearing of that soldier. Okay, don't believe me, think that might be hyperbole? Well, let's just take a look at the text of the legislation itself. 1. Requires each branch of the armed forces to fully utilize any applicable state extreme risk protection order program in the event a commanding officer determines that a member of the armed forces under the commanding officer's command is a covered individual for purposes of subsection B3. But there's more, because it also 2, requires each branch of the armed forces to fully participate in any judicial proceedings authorized under any applicable state extreme risk protection order program to impose, review, extend, modify, or terminate an extreme risk protection order for a current or former member of the armed forces. And that's dangerous language right there, because I don't know if it means a person who was active in the military at the time the order was then imposed and now they're out of the military, or does this mean for all of our veterans who have long since retired from active duty in the United States military? Now, like I said, no matter where you're stationed, you are going to be subject to that state law's red flag hearings, because the legislation specifically states the term applicable state extreme risk protection order program means an extreme risk protection order program of a state in which a covered individual resides or is physically present as part of such individual's military service. So theoretically, you could have residency in state A where they could bring the action. You could be currently serving at a base in state B and the action could be brought there as well. Now, who's covered by this act? That is, who could actually be red flagged by their commanding officer? Well, the legislation tells us the term covered individual means a member of the armed forces who, A, has been determined by their commanding officer to be unfit to carry or possess a firearm for the performance of official duties due to the member making a serious, credible threat of violence against one or more members of the armed forces, another person, himself or herself, or a military installation or facility. And then there's one other category. B is described in Section 922G4 of Title 18 United States Code to the extent such status is a basis for initiation of proceedings under an applicable state extreme risk protection order program. And that statute refers to those that have been previously determined as mentally defective. Now, I want you all to go back and watch this video right here, which talks about how some veterans, as they're getting a little bit older in years, may have a surrogate step in and help manage their finances. It's often a child or their spouse or somebody like that. However, the VA is going to determine that this person is no longer capable of managing their finances and therefore they are now mentally defective. And that theoretically then could lead to red flag hearings in all of those jurisdictions. And finally, what does it mean to mandate that the armed forces must fully cooperate in any red flag action hearing? Well, specifically, the legislation states the term fully participate in any judicial proceeding authorized under any applicable state extreme risk protection order program means, in the case of a branch of the armed forces, producing, upon the request, appropriate judicial personnel or a party to the judicial proceeding, evidence that may be relevant to the proceeding, notwithstanding the privacy regulations promulgated under Section 264C of the Health Insurance Portability and Accountability Act, better known as HIPAA. So yeah, essentially, they have to give them everything that they want, any records, and they have to appear and testify live if need be. Now, I don't think it's any secret that our veterans are suffering from some significant issues right now. The number of suicides that we're seeing on a daily basis from our veterans is absolutely, positively unacceptable. And so I recognize the great level of concern there is for our veterans. However, the last group of individuals who should ever be disarmed without due process of the law is the very individuals who put their life on the line so that all of us can enjoy and appreciate the inalienable Second Amendment rights as well as all of our other individual liberties. Listen, we're going to have to carefully watch this. The Senate bill, again, is 50-55, and the reason we need to watch this is that let us remember this was proposed by a Republican senator, which means that you may have some soft Republicans, I know some of you call them rhinos, who may be interested in this legislation. And of course, anybody with a D next to their name, well, any piece of civilian disarmament legislation, you know they absolutely adore it. We'll go ahead and link up the bill down below. And we'll also link up, if you want to make some comments to your representative, you may do so in a polite and professional manner. If you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information, it's down there in the description box. If you got an idea for a video we should be doing around here, click on that link right there. Let us know. It's probably going to be better than any idea we come up with. If If you want to subscribe to our monthly newsletter, the ability to do all of that is right down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.